Substantial change of circumstances in child custody claims. In order for the court to modify an existing child custody order, a litigant must prove that there has been a substantial change of circumstances affecting the welfare of the minor child or children. So let's dig down on that a little bit. North Carolina law states specifically what does and what does not constitute a substantial change of circumstances. Some of the things that don't necessarily constitute a substantial change of circumstances are things like when one parent moves from one location to another. The courts have stated that relocation in and of itself does not necessarily constitute a substantial change of circumstances. However, if that relocation makes the existing custody schedule no longer feasible, then it could be a substantial change of circumstances. For example, if both of the parties currently reside in North Carolina and one of the parties moves to California. Again, relocation in and of itself does not constitute a substantial change of circumstances. But in this instance, due to the physical distance between the parties' respective residences, the custodial schedule that's in place may no longer be feasible. Under these circumstances, the court would most likely determine that a substantial change of circumstances has occurred, and then the court would look at the best interest analysis. In the context of an original child custody action, the legal standard is the best interest of the child. And what the court has to do is the court has to listen to the evidence presented and decide what custodial arrangement is in the best interest of the child or children. In the context of a motion to modify custody, there is a different standard imposed. In order for a litigant to prevail on a motion to modify custody, they must first prove that there has been a substantial change of circumstances affecting the welfare of the minor child. Once a substantial change of circumstances has been proven, then the court will go to the best interest analysis. So, that same analysis that the court imposes on an original child custody determination is still going to be the polar star in the motion to modify, but only after the moving party has proven a substantial change of circumstances. A substantial change of circumstances can be a lot of different things. For example, if you had a parent that was a drug user previously, but now they've rehabilitated themselves and they're in a better position to parent the child, that in and of itself would be a substantial change of circumstances. Before they were incapable of providing adequate care, and now they are not. Now they've rehabilitated themselves and put themselves in a position where the court can reevaluate the child custody determination. Conversely, if a parent was once a fit and proper parent to provide care for the child, and now they're struggling with issues like substance abuse or mental health issues, and they're no longer fit to provide that care, that would be a substantial change of circumstances.